Hi, and welcome to this month's edition of Stephen Squibs Monthly Family Law CLE. I would personally like to thank Jacqueline Spence and the Affordable Law Center in West Palm Beach for sponsoring this episode of our CLE. Specifically, they paid the accreditation fee, which means more dollars goes to benefit the Center for Child Counseling. Thank you, Jacqueline, and we hope you enjoy this month's episode.
Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
And welcome to the 10th episode of Stephen Squibs Monthly Family Law Case Law Update. And this is our May 15th edition. Can't believe how fast time flies and how these accredited CLE hours just rack up. With me again, as always, my cohorts in crime, CARYN Stevens and GINA SZAPUCKI. Hey guys, how you doing?
Hi Eddie, good afternoon.
So we have some 20 cases to talk about, and the Florida bar has been way behind in posting credits, but if you look at your materials, we have gotten accreditation from episode 1 through 9, which is pretty good. They're a little behind due to COVID, so it's been very frustrating getting these accreditations, but we got them, plug them in, and get full credit for them. Also, we are now doing pre-registration for next year, and all of our faithful subscribers got an email with a link for a $200 registration fee. So that would be the entire next year, all 12 episodes, and usually we do bonus stuff too. $200, that's like the cost of a regular CLE. And let me remind you, this is all being done to benefit the Center for Child Counseling, which is a Palm Beach County 501c3, which not only are they making a trauma-informed community, but they're on the front lines dealing with kids going through trauma and making sure we have a healthy environment, and our teachers or medical professionals or family lawyers know the importance of being trauma-informed and adverse childhood experiences and the impact of ACEs on our youth and their continued growth. So those are the announcements. Claim your CLEs, sign up for next year, because $200 is going to be the best price out there, unless you're a judge or you work for legal aid, in which case we'll let you have it for free. So announcements out of the way, we go to our materials for the month. These are the actual cases that came out in Florida March of 2021. And CARYN, you start off with alimony.
Yes, I have the first 3 alimony cases. And by the way, like Eddie said, make sure you register, because it's a great deal for CLE credits. And while you're also supporting an awesome, really helpful agency here in Palm Beach County. So we'd love to have a bunch of you signing up again for next year. So first alimony case is the Odom case, which is number 1 in your materials. This is a case out of the 1st District. It was a dissolution of marriage case. And in this case, there was a 4-year marriage, and the wife pled for permanent alimony, claiming that she became disabled during the course of the marriage. There was no dispute that the wife had suffered multiple strokes, had brain surgery during the marriage, but went back to work each and every time after those medical incidents. And there was a great deal of testimony on the record about the jobs that the wife had held down during the marriage, even despite her health ailments. Wife's testimony at trial, she said that she lost her job because of her medical issues or because of medicine she was on, and things like that. But actually when the evidence, the other testimony from the employers and business records and employment records came out, it actually showed that the wife had quit her job multiple times. And actually the testimony that she had given wasn't quite as reliable as, it could have been. And actually she had never really been laid off. So after the court heard all of this evidence, the court only ordered that the wife receive bridge the gap alimony for 9 months, which of course was drastically different than when wife was planning on, I guess, her retirement payout here for permanent alimony for the rest of her life after a 4-year marriage. So wife appealed, and the first district said that the record supported the fact that the wife was only entitled to 9 months of bridge the gap alimony at a really low rate, and that there was substantial competent evidence to back that up. So that it was not an error to award her that. That's the Odom case. And the second case under alimony this month is the Potter versus Potter. And then there was a third party defendant veterinarian clinic. This is out of the first district up in Tallahassee. And in this case, there was these folks did the situation we see once in a while where they married each other, got divorced, then remarried each other. So every time you're writing those settlement agreements and saying in reconciliation and remarriage. So here's one of those examples where the Potters were that couple, and they were married the first marriage for 9 years. They were only apart for less than a year before they remarried the second time, which marriage lasted 8 years. So you had a 9-year, a small gap, and then an 8-year marriage. And when the court awarded the wife alimony, when they divorced the second time, the wife was awarded alimony in the context of both marriages being combined, which is different than some of the other case law authority we've seen out there in the state. But it's really that the court has broad discretion to do any equity between the parties when making an alimony award and determining alimony. So even though this was appealed, the first district said, hey, the court had broad discretionary authority. It considered the terms of the marriage. Wife had, during the first tranche, the first marriage, had supported the husband while he went through veterinarian school, became a veterinarian. She raised the children. They took their brief gap of the marriage, came back for 8 years. He set up a successful veterinarian practice, which was the third party defendant, and the wife worked there. So this, just based on the facts of this case and based on the fact of, the brief gap in their marriages, the court was affirmed that combining the marriages for the purposes of determining alimony was acceptable in this case because it was within the discretion of the court. So that is the Potter case. It's a long but interesting read. And then the next case under alimony is the Barrett case out of the 5th district. In this case, the wife had actually filed a 12-540 motion after the court had entered the final judgment dissolving the marriage. She claimed that the husband, now former husband, had underrepresented his income. He was, of course, a business owner, not a W-2 guy, and you know how difficult those can be. And she found evidence after trial to prove that he had lied about one of the clients. He was like a medical device sales guy and underreported a client that he was collecting income from. So she filed this 12-540 motion to set it aside based on fraud and new evidence and all of that. But what the court really focused on in this opinion is while the 12-540 was denied by the lower court, and that's what she appealed, the 5th district actually looked at the alimony award in and of itself while it was dealing with the 12-540 issue that was denied. And what this court had done at the lower court level is just taken the former husband's affidavit and found that he had a surplus of $1,500 and said, hey, that's what the wife is going to get in alimony. There was no determination as to her needs. They just said that she had some need in the final judgment, but there was no calculation of what the former wife actually needed, but just that she had some need. And so one can only figure that the court said, hey, of course, the former husband's affidavit is valid and, accurate, like all of them always are, and said, hey, $1,500 surplus, that's the number we're giving to the wife. So the 5th district said that was an error. You do need to calculate what her needs are specifically, and you can't just say, hey, it's what his surplus is meets her needs. But also more importantly, there was a retroactive alimony claim, and the court, instead of running a calculation and figuring out income during all the pendency of the case and what the wife's needs were, just simply said, hey, husband had paid her car payment and her car insurance. So, quote, this was at least his alimony obligation during the pendency of the case. And so the court denied her retroactive alimony claim improperly, and this was all reversed and remanded back to the lower court to fix those errors. And the next case is the King case.
Yeah, this is another alimony case. It also has a goodwill component, ED type issue we'll talk about later. But the alimony issue in this case is really a Zold matter. It dealt with a S corporation, and the court just based his husband's ability on the pass-through income that was reflected on his tax return, and gave like a $15,000 a month alimony award, I believe. And that didn't take into consideration all of the debts the corporation was paying with this pass-through income. So the first DCA basically found the husband's corporation to be an S corporation, and found that even though an S corporation income is directly taxable to a shareholder, that does not mean the shareholder will receive distributions in the amount equivalent to that to which is taxed. In fact, the S corporation may not make distributions to shareholders if the corporation would be unable to pay debts as they became due. In this case, the corporation did have a lot of debt maintenance, and by just using the pass-through income amount, that would prohibit this particular company from being able to pay its debts. The first went on to kind of state the Zold, we'll call it the Zold test, in context of an alimony determination. Undistributed pass-through income that an S corporation has retained for corporate purposes does not constitute income to the shareholder spouse. Then the burden shifts. Even so, the shareholder spouse has the burden to prove the corporation's retention of undistributed pass-through income is for corporate purposes and not for the purpose of avoiding alimony, child support, and attorney's fees obligations by reducing the shareholder spouse's amount available for income. So if you have a guy that's playing games, or a gal that's playing games by not making distributions that have normally historically been made, there's a backdoor kind of test here out of Zold. And that is the King alimony case. That takes us to appeals.
We have one case for appeals this month, case number 5. This is Sweeney versus Sweeney out of the 2nd District. And this appeal, again, is based on a final judgment, amended final judgment. And while the appellate court affirmed most issues, the one issue that is a non-final order and an appellate court cannot review is when there is a judgment that states an entitlement to fees but reserves on the amount. If those fees have not been ruled upon, then the appellate court cannot hear it. It's a non-final order. So again, this is something that we are seeing in these appellate cases, and it's good to remember that if there's no amount, that issue is not final, so the court cannot review it. That takes us to attorney's fees.
Back to me, the Palmater case out of the 2nd. This is kind of a interesting case. It dealt with appellate temporary fees. Someone received a $9,000 temporary appellate fees award, but when it came time to make their application for final appellate fees, they didn't make the request by the due date of the reply brief, which is the deadline to make a request for appellate attorney's fees. So it was an untimely request, and the trial court said, well, since you made an untimely request, you got to give back the $9,000 that was awarded you temporarily, and did an order of disgorgement. And the Palmater court kind of goes on to a discussion that, well, jurisdiction for temporary attorney fees is not the same as final appellate fees, and just because the motion for final appellate fees was untimely, that doesn't render the motion for temporary fees. It has no legal effect on that. They're two separate vehicles. So in this case, the court that made the person disgorge their temporary appellate fees, it was reversed. And now on to enforcement land.
We have 2 cases for enforcement, which I will be discussing. The first case is the Abdo v. Abdo case. I apologize if I said that incorrectly. It's from the 2nd District. And this case was very interesting. It did not necessarily involve our normal family law disputes. In fact, it had to do with a dispute between a whole bunch of siblings where they were all arguing over these ownership interests of adult websites and the income that it generates and essentially who gets what. It was, corporate entities. What specifically we'll be discussing in this case is contempt. So here, to note, this case has an extremely extensive history with the appellate court. There's been over 3 rulings from this court. So this appeal is specifying the last order from the appellate court, which would be the 3rd one. But the issue that this appellate court took upon for this is whether the circuit court held that this defendant, who was a brother, was found in contempt for violating the final judgment from the prior court's order. So here, he was found in contempt because he was required to return all this social media content, its documents, all of these things. And he allegedly failed to do this. So they filed a contempt motion against him. And in the final judgment, it said that this person, JEA, we'll call him defendant, the final judgment said that because he had to return all this social media and this documentation, in order for him to do this, he had to turn over all control of the websites. So he had to return everything. However, when the appellate court reviewed this and the findings from the contempt proceedings, they noted 3 different reasons why JEA, this defendant, could not be held in contempt. And as we are aware, in order to find someone in contempt, the final judgment has to be very clear. So the contemptor has to understand that they are required to do X, and if they fail to do this, they can be held in contempt. The order has to be so clear that someone would understand, if you don't do this, you're going to violate. So when the appellate court reviewed this most recent order, they listed the 3 reasons. And the first reason the appellate court stated is when they reviewed all the testimony and evidence from the contempt, they found that it was unclear how this defendant, in his individual capacity, me as JEA, could have provided access to a corporate entity that wasn't part of this original proceeding. So the court listed an entire analysis on this and said that because the final judgment was not clear on how he could have provided access to these documents, he couldn't properly comply. And because he couldn't comply, you couldn't hold him in contempt. It was very general. Give over this company and everything that comes with it. The second reason that the appellate court found this was not a contempt was because in the contempt hearing, it was unclear who actually controlled this social media asset that the defendant was ordered to deliver by the final judgment. In the contempt proceeding, there was testimony and evidence presented that a witness came in and testified that the defendant wasn't even the holder of the social media account that the court ordered him to give back. And then further, it was stated that, yes, I acknowledge the defendant isn't even the holder, but because it's his son, he has control over the son. And because of that reason, the son should be required to give over the social media account. And the appellate court said, well, wait, there was a whole bunch of testimony on how this defendant didn't even have clear control. So again, there's no way he could be in contempt because he had no idea how to purge this by giving the company back. The third and most important reason which the appellate court stresses from this case is that not only for those two reasons that I referenced about evidence and testimony, but the trial court improperly exercised jurisdiction and they exceeded their authority. So when an appellate court issues a mandate, okay, the trial court has the authority. The trial court does not have authority to take any other action than what the appellate court directs the trial court to do. That's essentially what a mandate is. And here, the appellate court said that was the most important reason because, as I was explaining in the beginning, because there were 3 other appeal cases out there, in the very first case, the court found that they could not pierce the corporate veil of this entity. So therefore, the brothers kept trying to get around this corporate entity, and they found that this defendant, JEA, could still provide these this information from this company. And the court said, no, that's incorrect. You cannot do that. And for all of those reasons, the court found that it was impossible for this defendant to be held in contempt. There was no clear direction on how he was supposed to return all of this information. And therefore, for those reasons, the court reversed. That takes us to the next case of enforcement, case number 8. This is the Suarez v. Suarez case out of the 3rd District. This was another motion for contempt that was filed. Just to give you a little bit of a backstory here, parties were married, parties entered into a marital settlement agreement, so everything was voluntary, and it discussed a bunch of provisions. Now, here, they entered into an agreement with alimony and equitable distribution. So what had happened is the former wife essentially filed a motion for contempt on the former husband, alleging that the former husband failed to comply with these provisions of alimony, and therefore he should be held in contempt. The former husband attempted to dismiss her motion for contempt, stating that I wasn't required to pay alimony. This was in condition of equitable distribution. Therefore, you can't hold me in contempt. The court said essentially too bad, so sad, and they found former husband in contempt. So he appealed. So when the appellate court took this into account, they had various reasons. One is the trial court said mom was in contempt of court because this agreement was ambiguous, meaning they were both arguing one's alimony and one's equitable distribution. The trial court said, well, this is ambiguous, so let's take in parole evidence and hear from both parties, which is how they got to the motion for contempt. Now, what the appellate court did here is, and I'll go into it in a little bit about how you get into parole evidence and whatnot. To better understand this case, I want to explain the provisions. So, former husband was required to make a lump sum payment to former wife for equitable distribution. The caveat was you had your headers, like a lot of us do in marital settlement agreements. You have alimony and you have equitable distribution. Under alimony, the former husband did state he was to make a lump sum payment, and it referenced all the reasons why. It was for all these properties, churches, nonprofit organizations. It had no explanation of former wife has a need, here's an ability, and I'm paying you this. It was very clear on, I'm paying you this lump sum alimony for these properties. And then in another paragraph, it listed equitable distribution, and it reaffirmed all the properties that were discussed in the alimony provision that as to why wife was receiving this lump sum payment. So what happened was the appellate court found that the trial court erred by allowing parole evidence because this agreement was not ambiguous. In fact, it was very unambiguous, and the former husband couldn't be held in contempt. In order to be held in contempt, if it's for equitable distribution, we cannot file contempt motions. It can only be enforced in the same way as a creditor would to somebody to a debtor. It's well established in Florida law that even though you can give a lump sum payment of alimony is allowed for equitable distribution. And if it's so unambiguous, even though it says alimony, if it's for that sole purpose of equitable distribution, it should not be a contempt proceeding. It should be a motion to enforce. So the appellate court said that when they looked through the entirety of this agreement, not just the headlines, it was very clear that this was a non-modifiable lump sum alimony that was solely to be paid in exchange for her interests in those properties, the church, the nonprofit business, all of these other things. And the lump sum payment was specifically representing her 1/2 interest in all these properties. So again, there's no other language of alimony about years and all of these things. And in another section, the agreement also stated that they release each other from alimony and support or maintenance. And the appellate court said, this doesn't make it ambiguous. In fact, it helps us by saying the parties acknowledge they don't want alimony. And we're releasing any other claims of alimony. So a good practice tip is when you are about to file a motion for contempt, always, read the MSA and make sure that it is not for the purposes of equitable distribution. If it is, then that is, the court cannot hold the spouse in contempt for that, and different avenue has to be taken. That takes us to the start of equitable distribution. We are now on number 9. It's from the 4th district. It's Fernandez. I'm not even going to try to say that. I'll butcher it. V. Fernandez. This was a post-dissolution matter. The wife appealed 6 issues of the final judgment. The appellate court affirmed 5 out of the 6, and the 6th one that we will be discussing that was reversed is equitable distribution. This case is wonderful because it is a great practice tip, and here the appellate court reversed it by saying it should be reversed because the trial court ordered an unequal equitable distribution without laying out any of the factors of equitable distribution. So therefore it should be reversed. And here's why. When the appellate court reviewed all of the testimony from the final hearing, they found that the court awarded the husband a much higher equitable distribution payment than the wife. The husband was awarded a little over $246,000, and the wife received a total of a little over $133,000. They tried to equalize the payment by having husband make a payment to the wife. However, they also included a lot of findings that this is the reason why husband is receiving more as an unequal equitable distribution payment. However, the court did not make any reference to any of the factors that we look for all the time, Florida Statute 61075, to support equitable distribution in every case. Now, in order for equitable distribution to happen, it's clear that you must make those factual findings of those factors that are listed in that statute when the parties haven't entered into a stipulation or an agreement hasn't been filed as to equitable distribution. And that's exactly what happened here. When the trial court entered the final judgment, they referenced that all they referenced was that the wife should receive alimony because of the factors listed in 61.075 and the alimony statute. They did not go into any detail whatsoever as to why they found unequal equitable distribution in all of these things. And of course, the parties did not enter into a stipulation about anything with equitable distribution and how to determine those assets. Therefore, it is reversed on that issue, and the trial court isn't required to reopen the whole case, but they have to lay out those findings as to how they got there. So this case is a great practice tip that when judges ask us to potentially prepare final judgments, make sure you list out those factors, help the judge, and it's a good reference for you too, especially when preparing for cases. Go through those factors. Am I hitting what I should? It's very important. This takes us to the next case, case 10, Murphy v. Murphy. This is the second DCA case where the former husband appealed an amended final judgment with his contention that he believes the trial court erred by not using the correct valuation date for determining certain assets and liabilities, more specifically his retirement accounts. In the trial court, the husband, this is interesting, the husband filed his petition in August of 2014, but he did not serve his wife until July of 2015. So just about a year. So what essentially the court said was there was a lot of testimony that because the husband was still, as the evidence would show, trying to work on the marriage, the parties were still living in the same house, they were going to counseling, all of these things. The trial court, instead of using the date he filed, which was in August of 2014, they used the date of the final hearing to value his retirement account for a marital asset and liability purpose. And here the rule is pretty clear that if there's no separation agreement between the parties, the cutoff date for the determining assets and liabilities is the date of filing for petition of dissolution of marriage. So here, former husband contended that when I filed in August of 2014, that is the date that the court should have used to determine what is marital in my retirement account and how much is non-marital from what he continued to contribute once he filed. Here, although the trial court correctly identified that yes, this retirement account is marital, they did improperly use his final hearing date to value everything else. And therefore they failed to address how all the contributions that the former husband continued to make after August of 2014 would be factored into this equitable distribution as his non-marital asset. So for that reason, the appellate court reversed and said, trial court, you must use this date of filing date, and then you have to determine how to classify all the former husband's post-filing contributions from this retirement account, because that still has to be factored into equitable distribution. So, always look for those dates and make sure we're presenting the correct evidence.
Our next case is number 11 in the materials, King, and great job, Gina, doing 4 cases in a row. Woo! King v. King, we talked about it in Alimony. Now we're talking about it in ED, specifically the personal goodwill. Husband was a little miffed that his insurance company was valued pretty highly, and the wife's expert only put 7.3% as his personal goodwill. And we know for the husband wants that percentage to be as high as possible, because when making an equitable distribution, the court has to exclude from its valuation of a business the amount of a party's personal goodwill. That goes back to the thought that personal goodwill represents a person's future earning capacity, and that should not be in the value of equitable distribution. So in this case, to determine the amount of the husband's personal goodwill that would be excluded, the wife's expert chose 7.3% by relying on something called DealStats database. And he looked at transactions in this database, which allowed parties to the transaction to report certain data points, like the value of the covenant not to compete. They didn't have to, they could, it was voluntary. And all of this information, the expert basically looked at what was self-reported and did an average of what they valued this non-compete clause at, and came up with 7.3%. On cross-examination, it was discovered that these comps, were from different states over 20 years, and there wasn't much rhyme or reason to really getting to that number. The trial court was reversed and remanded on this issue simply because what that expert relied on did not provide competent evidence to support the trial court's determination of the amount of personal goodwill. So the whole issue was remanded back to the trial court. Takes us to case 12.
The next case is case 12, which is the Calvarese versus Calvarese case out of the 4th District in Broward County. And this was a really short opinion. Both wife and husband had both filed motions for interim partial equitable distributions under 61075, subsection 5, and each had allegedly asked to have an IRA, a Roth IRA, interimly distributed to the parties, I'm assuming to pay fees or something like that. And the trial court not only granted that motion dividing the Roth IRA, but also threw in that the traditional IRA that nobody asked for distribution of should also be distributed on an interim basis as well. And that was reversed and remanded because there was no good cause to grant an interim equitable distribution on an IRA that no one had asked for in any of their motions. So that's what the Calvarese case is about. Next one is 13, the Roth case.
Oh, this is a fun personal injury classification dissipation case. We had personal settlements from an accident. And we know as family law practitioners that to figure out what portion of that award is marital, you have to take out the pain and suffering and look at just what portion include lost wages, earnings during the marriage, medical expenses paid. That's the marital portion. In this case, no evidence was presented either way, so the court really couldn't figure that issue out. Regardless, the amount from the proceeds of the settlement were depleted during the pendency of the case. There was no evidence of dissipation. So the appellate court kind of latched on to the no dissipation evidence. If you deplete an asset during the pendency, we're not going to worry about it unless you protect the record and show dissipation. So Roth case was personal injury settlement with a twist. Number 14, injunctions.
Yes, we're going to hop over to injunctions. There's one case this month coming out of the injunction world. This is the Winter and Gutierrez case out of the 5th. And the petitioner, Miss Winter or Mr. Winter, I'm not even sure, I think it was 2 women, they had filed for an injunction, and the petition talked about a whole bunch of issues and instances that occurred in August of 2020, but then petitioner shows up at the injunction hearing and testifies about things that happened in April of 2020, things that were not included in her petition and not pled within the injunction filing that she had made. And the record, the 5th District notes in the record that the court ruled before the petitioner had even finished presenting all the evidence about the August 2020 issues. And therefore, it was clear that the court was granting the injunction permanently based on the April 2020 issues, because that's what the petitioner testified to first, which was not in her petition. So you have all sorts of due process issues, that the respondent wasn't on notice of what was going to be brought up, what was pled for, couldn't properly defend against, and therefore this was reversed and remanded back with directions, because it was very clear from the record that the injunction was granted solely on the things that were not included in the petition and were heard for the very first time at the hearing. So that is our injunction case for this month, and now we're going to go hop over to parenting.
We have a really rough read. The RSSK matter dealt with the modification of a child that was being sexually abused by former wife's new husband. At the modification trial, after the former husband put on his case, the court entered directed verdict, even though the sexual abuse was not contested, and basically found that after examining all the competent evidence in this case, if we look at the long-term effects of the abuse on the child, we cannot say those are permanent. The court cannot say that this is a situation where the child is traumatized for life or will be depressed and suicidal for life. That's really has nothing to do with the grounds for modification. And the trial court also observed that the new husband that did the abuse on the child was in jail awaiting trial, facing a lifetime sentence. Even if he was acquitted, former wife had begun divorce proceedings, and there was very unlikely any chance that the child would have contact with that person who abused them. Regardless, there's really no directed verdict in a non-jury trial, so that language is wrong. If you look at the rules of procedure, there is a procedure for a motion for involuntary dismissal, which is what you make after the plaintiff or the petitioner hasn't met their elements. But in this case, the elements, the court cut the former husband off at the knees before he was even, able to get into the determination of what's in the best interest of the child. So the appellate court reversed this trial court order and said, well, of course, this type of abuse is a substantial, meets the prongs. And now you have to go back and look at what's in the best interest of the child. That's the RS case.
That takes us to the next case of parenting, number 16, Aliyah v. Larkin. This is a 4th district case where the father appealed a petition for modification of parental responsibility and time sharing that was filed by the mother. The appellate court affirmed on both issues. The father suggested that all the evidence that was presented at trial showed this, time sharing and parental responsibility should not be modified because all we have is an acrimonious relationship. And as we are aware, an acrimonious relationship on its own is not enough to warrant a modification of time sharing and parental responsibility. However, the appellate court affirmed because there was a competent substantial evidence to support this court's ruling of time sharing. The trial court found that yes, they had an extremely acrimonious relationship, but there was also a lot of evidence on battery from the father against the mother post modification, as well as a lot of other physical acts. There was a lot of evidence on his continued violations of the current parenting plan, where he continuously prevented communication between mom and child. Based on all of this evidence, the appellate court affirmed. They said, yes, time sharing is changed. There was enough evidence to support that. The father also alleged in the appellate court that decision-making should not have been warranted, where the trial court awarded mom ultimate decision-making as to the medical issues. And again, the original parenting plans said the parties have shared parental. However, the appellate court affirmed because, again, there was a lot of evidence to show that an ultimate decision-making for medical decisions was warranted. there was over 5 reasons the appellate court cited based on the evidence that was presented at trial. The appellate court found that there was a whole bunch of evidence where, yes, although the parties do not communicate and their relationship is extremely acrimonious, dad also continuously to refuse to take the child to medical appointments. The court found that when he did offer to take the child to medical appointments, he wasn't even doing it. His girlfriend was the one who would be taking the child to the medical appointments. The father, there was evidence that was presented that father failed to give this minor child the necessary medicine that was prescribed while in the father's care. And additionally, the father knew very little details concerning of this child's health care. The trial court weighed all these factors and they determined that even when the parties disagree, based on all of these factors, mom should have ultimate decision-making over these medical decisions for the court. And for those reasons, that's why it was affirmed, which now takes us to procedure.
We have 2 procedure cases, 17 and 18. 17 is a classic general magistrate, how do you deal with exceptions kind of case. And in Hearst v. Maines, the judge doing the exceptions hearing disagreed with the magistrate and basically said on the record, I'm just saying I see it differently. That doesn't mean I have to accept the magistrate's findings. I can see things differently, and reasonable minds differ. Well, not under exceptions. A judge does not have that kind of discretion, and the second DCA let this judge know, reversed it, and again pointed out the rules. Once a trial court appoints a magistrate to take testimony and make findings, it loses the prerogative of substituting its judgment for that of the magistrate. The trial court assumes an appellate role. The trial court review of the general magistrate's recommendations is limited to determining whether the general magistrate's findings of fact were supported by competent evidence, and whether the general magistrate either made a clearly erroneous legal conclusion or misconceived the legal effect of the evidence. So when a circuit court judge is overseeing or looking at magistrate's reports, reasonable minds cannot differ. There's got to be more of an appellate standard. The next and final procedure case in the materials for this month, Barrett v. Barrett, number 18 in the materials, dealt with a final judgment of divorce. The husband was sold medical devices, and after the divorce, wife found evidence that even though he said he got $0 from Dr. X, he got $15,000 from Dr. X. So she filed a 12.530 and a 12.540 motion. 12.540 dealing with the fraud is the one that, struck a nerve, because the court disposed of it before giving an evidentiary hearing, and the 5th DCA came back and said, well, if you have a well-pled 12.540 motion and it specifically alleges fraud, you got to give that person a bite at the apple and let them have an evidentiary hearing. Those are all of the procedure cases for this month.
We're going to hop over to support and temporary relief as our last 2 sections, last 2 cases for this month. And the first case under support is the Maali case versus Maali. This is out of the 5th district. And this was a case where the husband was ordered to pay the private school education tuition for all 3 of the parties' children, when there was clear evidence that he probably could not afford that. So this is one of those cases where in a vacuum, he might have had an ability to pay tuition for the children for their all 3 of their private school educations. But in a full spectrum view of this case, the husband was ordered to pay a hefty sum of alimony to the wife, child support, all the expenses on the marital home. And when you look at this as an entire picture, there really wasn't enough money left for him to cover all the private school education of the children as well. So based upon the evidence and the record that he really couldn't afford this, the private school education award was reversed. So that is the Maali case. And then the last case this month is under temporary relief. This is the Wilkins case out of the 1st District. And this was a case involving a temporary relief hearing. And at the time of the temporary relief hearing, there was some argument made by the husband's attorney that the wife should have income imputed to her. And this was a stay-at-home mom who had been home for many years raising the party's child. And she also had a child from a prior relationship as well that she was raising. And the parties had made an agreement that she would raise that child and their child in common while finishing her nursing degree. And on a temporary basis, this court, the 1st District, said that great deference should be given to the agreement of the parties about how they were going to parent and who was staying home, at least on a temporary basis. So imputing a large sum of income that this wife should have been out and earning on a temporary basis was not proper and not supported by any substantial competent evidence on at least a temporary basis for the purposes of this case. So this case was also reversed, and this was on a temporary order. So that is our last case for this month.
Thank you, Karen and Gina. And that takes us through these cases and ends our episode. And just a reminder, check out the link in the materials to sign up for episode 2. Right now we have early bird registration for $250, but we have a special deal for all of our 88 subscribers from episode season 1. So you get $50 off, and eventually it's going to be $300 once the early bird special is gone. And we just think by lowering the price, we can have a lot more people subscribe and do a whole lot more good for the Center for Child Counseling. There's also the Mental Health 2nd Annual Summit that is in your materials that you can register for. It's a really good, meaningful CLE that focuses on alcohol and substance dependency this year. And in addition, don't forget to claim your CLE hours. They're all in the materials. So those are the announcements for this week, this month, May. We'll see you guys in June. We are 5/6 the way through this season. It's been a lot of fun. And if you guys have enjoyed it, please share the word. Tell your friends to subscribe. And if anyone has any quotes, we're putting together some fun marketing materials to advertise this to everyone else. We would love, to publish your quote, like Eddie is awesome. That would be super, or something like that. With that, go out and do something that matters, and everybody have a great month.
Thank you for joining us for this month's edition of Stephen Squibs' Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.